We say that the proposal to extend the constitutional family to other durable relationships is unnecessary and introduces huge uncertainty into our fundamental law. And when I say it's unnecessary, we're of the view that there is nothing that a single parent or a de facto cohabiting couple cannot be given by statute as long as the Oireachtas is so minded to do by way of protections, safeguards and additional rights. We are a group of lawyers. We are ad hoc, established for the purpose of commenting and expressing our views on the two proposed amendments to the Constitution, the 39th and the 40th Amendment to the Constitution. We're a group of people from very diverse political outlooks. Some of us might be considered conservatives, some of us liberals, some of us in the middle. And in addition to that, we have, in relation to previous referendums, a very mixed record of how we voted this way and that on the issue. So this is not the usual suspects coming out in any sense. We are an ad hoc group of people who have very strong views about the 39th and the 40th Amendments to the Constitution. I want at the beginning to make the point that all of my experience, and I've spoken to the media across the country, radio programmes right across the country, is there is vast confusion about what this are, and people simply do not know what these two amendments are all about. It's very simple to put up a notice saying family yes, care yes, but nobody knows what that actually means. And the sad fact is that the great majority of people are still in a state of not having access to the real issues in this, in the real legal issues and constitutional issues which are involved in this referendum. I will be pointing out later that part of the blame for this arises from the fact that the government put through the two referendum bills in a matter of hours in each house in the Oireachtas using a guillotine. They claimed before Christmas, I was just looking at it today, that they would consider any amendments. But when push came to shove, they put down a motion at the beginning of each session where amendments were to be considered, saying it didn't matter what happened, there would be a single vote at the end of it, and the bills would go through unamended. So that's the sad situation that we have found ourselves in. Secondly, if they had gone through the normal procedure of having pre-legislative scrutiny, these bills would have gone to a committee of the Oireachtas, or at least one committee of the Oireachtas. Departmental officials would have been summoned in to say what are the implications for tax law, succession law, welfare law, all areas of law that you can imagine, family law. All of these issues would have been teased out, and the committee members would have been able to ask questions about the implications of widening the definition of family from marital families to non-marital families in a huge number of areas. But instead of that, what the government did was to convene an interdepartmental group. The interdepartmental group met on at least 16 occasions in 2023. According to the Taoiseach, Leo Varadkar, it considered the pros and cons, the ups and downs, as he put it, of various wordings and the implications of the wordings that were chosen for national policy. But when we submitted in the Senate Independent Group, we submitted an FOI request to see what were the issues that were considered in that interdepartmental process, and what did the various departments consider was good and bad about the proposed wording. We were told that it was not in the public interest that these things should be made public until the public had voted. Now, for reasons that I will, in other words, that it was in the public interest that the public should be kept in the dark as to what the government really thought, or what the Departments of State really thought about the government's proposals. And the reasons given, the FOI refusal was an elaborate document, and the reasons given are just simply don't stand up. They say it violates the McKenna principles and the McChrystal principles for the views of departments to be known by the public before they vote in a referendum. And yet, the day after, it's very clear from an answer given by Minister O'Gorman to a Dáil deputy, Carol Nolan, that they intend publishing, they don't object to publishing the day after the people have exercised their ballots. And we find that to be absolutely extraordinary behaviour by a democratic government, especially one which effectively bulldozed this through both houses and completely abrogated the process of pre-legislative scrutiny. The legislators were given no access to what various departments of state considered to be the implications of the wording that were put before them. So we have here in this document dealt with a number of those issues. And if I could just briefly go through the bullet points at the beginning. We say that the proposal to extend the constitutional family to other durable relationships is unnecessary and introduces huge uncertainty into our fundamental law. And when I say it's unnecessary, we're of the view that there is nothing that a single parent or a de facto cohabiting couple cannot be given by statute as long as the Oireachtas is so minded to do by way of protection, safeguards and additional rights. So it's unnecessary to change the constitution to address any issues that people in those situations actually have. And the uncertainty that it brings in is this, that in the course of the Seanad debate, an amendment was put down which was guillotined aside. It didn't get any proper consideration. But in the course of the Seanad debate, an amendment was put down saying that the other durable relationships would be those decided by the Oireachtas having considered the matter and designated as such by law. And Minister O'Gorman said that that would in fact introduce a differential approach, is what he said, between families under the Constitution. And whatever he meant by that, it wasn't quite clear, but he said there would be no differential approach and that all families who are considered to be families either by way of marriage or durable relationships would be on the same footing in the Constitution. Now, the second thing we say is that the rejection of the government of that amendment effectively gives to the courts the role of determining what other durable relationships means. You'll find in the document a number of government supporters and yes vote supporters saying they don't know what it means. And it has never been made clear what it means. And every attempt to ask people in office what does durable relationship mean gets confused, half explanations. Some of them are mutually contradictory. And in the end, they say this will be a matter for the courts. Now, we want to emphasise one thing. Courts do not decide on an afternoon what the Constitution means in blank. They only decide cases where two people with a dispute come before them, and one of them contends for one thing and the other contends for the other. So the process of determining what durable relationships actually means is in fact one which in this constitutional set of amendments you are being asked to say, you'll find out later, you'll find out when hard cases are decided, you won't know what it means the day you vote. Then we've dealt with the third bullet point there, that the door will be open to what we call concurrent or successive families with multiple partners common to each. And I'll give you a very simple example. A single mother with her child, according to Minister O'Gorman, but it's not obvious from the text, is to be considered a family for the purpose of the Constitution, even though there's not even a mention of that proposition in the text. But that's what he hopes will be the case. If she moves in with a man or allows a man to move in with her, and they have another child, and they have a relationship that lasts for 2 years, the question that will arise inevitably is, does her first family still exist, or is it subsumed into a second family? So is the is the man who's moved in a family relationship with the child of whom he is not the father. Just this is a simple example. If he eventually moves on and moves out of that arrangement and meets somebody else, does the durable relationship family that he has just left still continue to exist, or does family number one come back into existence with an extra child in
it? Less durable.
less durable. So, and then eventually, I mean, we have an example here, and we hope it's not that nobody sort of regards it as flippant. But I mean, we set out on pages 14 and 15 questions about that kind of sequence. Can a male partner be the man in two families at the same time? And can somebody leave a durable relationship and then get married in circumstances that he leaves effectively two families in existence? Another point is that the Constitution will still contain a provision that people who marry are not allowed to divorce unless they get a court order. And courts are prohibited from giving a court order dissolving a marriage unless proper provision is made for the as parties to the marriage, the spouses and the children of the dependent children of that marriage. That provision for people who are married, families who are married, will not apply to people who just walk out the door. I mean, there'll be no court process whereby proper provision is made before the man in this scenario I was mentioning goes on to form another relationship and takes on extra obligations. The next bullet point there is that
you have 14 points though, Michael, so you're like President Wilson with his 14 points.
There will be long-term consequences. And government ministers are saying, the Oireachtas will still be able to legislate. Yes, it will be able to legislate. But I thought it was able to legislate until the O'Mara case for widows' pensions, and it found out that the Constitution meant something different from what the Oireachtas thought it meant. In the famous case of the tax case, the Murphy case, the Oireachtas was treating unmarried people more favourably than married people, and the provisions of Article 41(2) were invoked by the court to invalidate sections of the Income Tax Act. In the O'Mara case, the provisions of the equality provisions of the Constitution and the Children's Amendment were invoked to overturn the Social Welfare Act. And I was just saying here to my colleagues at the table, when I think back to the children referendum, nobody at the time said that probably would put widows' pensions into a different category and would have an effect that someday the Supreme Court would come and say that the Social Welfare Act was partly unconstitutional. So when we say there are going to be implications for family law, for family property rights divisions, succession law, pension law, tax law, welfare law, migration and residence law, the government keeps on saying, no, there aren't. This is just broad brush stuff. But I mean, you could say that the children referendum is broad brush stuff, but it actually has an effect. And one of the points we make in our overview section is that the Constitution must be construed as a whole and is construed as a whole. And the Supreme Court, when it's deciding any case, or the other courts, are obliged to have regard and to give meaning to every word that is put into it. So, you can't just avoid all of this. Then we make the point that deleting Article 41.2, which is the one which refers to the contribution that women make in the home as parents, is going to pull the blocks out of the Murphy decision, the L&L decision, which was to do with maintenance, and you'll see there Mr. Justice Finlay's judgment in that. And it also, there's a more up-to-date case, the DT and CT case, where post-divorce, the very words that we are now taking out of the Constitution were invoked by the Supreme Court to say that decides and determines what proper provision actually is. If you don't, if a spouse in a divorce situation is going to be obliged to leave the house, you have to look to Article 40. To work outside the house, you have to look to Article 41.2 to determine whether that is in fact proper provision within the meaning of the divorce clause of the Constitution.